So my friends and colleagues, today we have been here for the webinar on law of bail. Before that, I'll confirm if I'm audible to all.
Yeah, it's audible.
Oh, okay.
Yeah.
So the topic for the day is law of bail. Now, friends, bail has nowhere been defined under the Indian Penal Code or Code of Criminal Procedure or any other law in India. Before coming to the webinar, I will introduce myself. I'm Advocate Ashish Swar. I'm practicing in the state of Goa before the Honorable Bombay High Court, Panjim branch. And I've been in practice since past 5 years. Now, before coming to the law of bail, I will briefly discuss how the concept of bail evolved in India. Now, we all know India was being ruled by Hindu rulers and there were Hindu kingdoms in India. The criminal jurisprudence of Hindus says that there was a concept of quick trial. The trials used to be conducted within a span of 1 to 2 days, and hence there was no question of bail in India at that point of time during Hindu kingdoms. In the year 1526, Mohammedans invaded India, and India was being ruled by Muslim rulers. And there is an interesting story as to how the concept of bail evolved. A guy named Makunai from Italy happened to visit India. At that point of time, he was being charged under a false theft case. After he being charged for a false theft case, he applied for release before the ruler of Punjab. This is during the Mohammedan rule. The ruler of Punjab directed the police officer. At that point of time, the police officer was known as Kotwal to release the Makunai. However, Kotwal defied the ruler and told Makunai to give a surety in case he wants to get himself released. And this is how the concept of bail evolved. At that point of time, there were two types of bonds taken by the Nizamat Adalat courts or Faujdari courts which were prevailing at the time of Muslim rulers ruling India. There were two bonds, which one was called as Muchalka and other one was called as Zamanat, that is surety, and Muchalka is a personal bond. We all know then how East India Company came India. East India Company started interfering with the Nizamat Adalats and Faujdari courts, and slowly the Britain formed their imperial government and colonized India. The concept of bail in England is also because of an interesting story. In UK, the jails were being crowded at that point of time. Some point of time in the 18th century, a disease, what we call it as a contagious disease, started spreading in the jails. To reduce the amount of people from the jail, rulers in Britain started releasing the inmates by taking surety, and that's how the concept of bail evolved in England. Now, in India, the law relating to the bail was regulated by CRPC 1861. Then it was changed to 1872, and now at present we have CRPC 1973, which discusses the law relating to bail in India. The sections which deal with the law of bail in India, they are 436, 437, 438, and 439. Now, as I have stated earlier, there is no definition of bail mentioned anywhere in any of the courts in India. However, there are two definitions under section 2 subclause. I don't remember the subclause, which talks about the bailable offense and non-bailable offense. Now, the difference between bailable offense and non-bailable offense, we need to understand. Bailable offense is the one wherein the bail is the matter of right and the provision has been laid down under section 436. Now, non-bailable offense is the one wherein the bail is not the matter of the right, but it depends upon the discretion of the court whether to grant the bail or not. The word non-bailable doesn't mean that bail cannot be granted at all. It depends upon the discretion of honorable court to grant the bail. Now, bailable offense, with respect of bailable offense, the law is well settled. A person can give the surety at the police station and police officer has the right to give the bail at the police station. However, if person is not able to give surety at the police station within 24 hours, that person needs to be produced before honorable court. In case of bailable offenses, then he can take the bail from the court. With respect of non-bailable offense, police has no right to give the bail and it is for the court to grant the bail. We need to understand the section 437, which talks about the non-bailable offenses. Now, bailable offenses are less serious in nature, which includes road accidents. Road accidents, we could say some minor petty offenses wherein the bail could be granted. With respect of non-bailable offense, the offenses are more serious in nature, which includes rape, murder, attempt to murder, cheating. These are some of the non-bailable offenses. Cheating sometimes is bailable as well. Now, friends, there is a maxim, or what we call it as a doctrine, which says presumption of innocence unless the guilt is being proved. On the basis of the same doctrine, the concept of bail has been evolved. Now, a person is being arrested. He is being arrested on the basis of accusations. It will not be rightful to keep him in the jail only on the basis of accusations which are being made against him and which could be false. Hence, a person needs to be granted bail. Now, I've spoken about 436, 437. We will restrict our webinar only to the law of regular bail. There is also a concept called as anticipatory bail, or the bail which is being taken by a person who is apprehending the arrest. The provisions relating to the anticipatory bail have been laid down under section 438 of the Code of Criminal Procedure. Now, friends, procedure for filing the bail is very important. The schedules in CRPC, which are given either at the end of the section or a separate schedule, there is mention as to the section and the offense and tribal by which court. Now, you cannot file a regular bail of rape before JMFC. You can file it, but it will be rejected for the want of jurisdiction. A judicial magistrate first class do not have jurisdiction to try the matter which is pertains to sessions court. Now, some of the matters, including cheating, robbery, theft, are being triable by JMFC. Bail has to be filed before JMFC. Certain offenses like murder, rape, attempt to murder, these have to be filed before Honorable Sessions Court. Now, the procedure for filing bail. I think most of us are advocates and we'll all have done a bail sometime or the other. I will tell the practice which is being prevailing in the state of Goa with respect of bail and how we do it. We get phone advocates from the relatives or the police officers sometimes, that or from the client themselves, that we have been arrested. Now, Article 22 of the Constitution of India, it makes a mandatory for the police officer to inform a person who is being detained or arrested, to let him talk to his family member, or let police officer inform the family member of the person who is being arrested. So any person who is being arrested, it is necessary that the family member is being informed. Once we receive the information that a person has been arrested, what we do is we go to the police station and ask the details, that is a crime number and the sections which are being involved. Sometimes a police officer is good, he gives us the details. Sometimes he doesn't. Then what could be done? How could we find out the crime number? In many states, the details of FIR have to be uploaded on the website. We can get the information from that. In certain cases, if it is not possible or police is not disclosing the crime number or the section, then we can move an application to the court, JMFC, stating that the offense and the crime number be disclosed to us. Because the provision in law says that when an FIR is being registered, it is mandatory for police to inform the nearest JMFC that the FIR has been registered against a person. Now, friends, I was on the procedure of filing the bail. Now, the Goa procedure, what we do is we go to the police station, we take the signatures of the accused and directly file before the court. And then the court, the JMFC's procedure, the court issue notices to the police inspector of the concerned police station and direct him to file the reply. Once the reply is being filed, the arguments take place and then court delivers the judgment. It is very well settled law that bail is the right and jail is the exception. So normally the bail matters are not being dismissed because it is a matter of the right. And with respect of non-bailable offenses, it is a matter of right subject to the discretion of the Honorable Court. Now, while granting the bail, what are the factors which are being considered by the JMFC are being well settled, or the law is well settled with respect of that by virtue of various judgments of Honorable Supreme Court of India? When a person applies for the bail, the court will consider following factors which I am going to discuss while granting him the bail or rejecting his application. One of the factors is that whether the person is an habitual offender, whether there is a past history of the person who is being arrested. Secondly, whether there is an apprehension that a person who is being released on bail will move or will go and threaten the witnesses. That is also being considered. Thirdly, if there is a recovery pending or the weapons have to be recovered, that has to be considered. Before recovery, the bail may not be granted because a person may get out of the jail and go and destroy the evidence. That is also being considered. Court will also consider if the co-accused are absconding. There are various other factors that are also considered. Now, when the bail is being granted, it is granted subject to certain conditions. One of the conditions is that a person who is being granted bail has to furnish surety. Now, what does surety means? It means zamanat. A person who wants to get out of the jail needs to furnish surety. That is, the other person has to sign for him and take his guarantee that in case he is not able to come to the court during the trial, I shall owe the responsibility. Surety can be given in the form of monetary bond or the property papers. The amount of surety will range from 10,000 to 50,000 depending upon the crime which you committed. Now, along with the surety, a personal bond is also required to be signed by the accused, wherein he undertakes to pay a certain amount of money which is being imposed by the court in case of his failure to attend the hearings. Certain cases, court may also ask for a solvent surety. Now, solvent surety is the one who is having a strong financial background and it submits strong documents like property documents or the bank documents or the papers from the CA. The role of surety is only restricted to making it sure that if a person who is being granted bail doesn't appear before the court, he shall make it sure that he appears before the court, or he shall make it happen that a person is being brought before the court by him. In case that person, the surety is not able to get the arrested person back to the court during the course of trial, the surety may be forfeited, which means the amount will be forfeited. There is no personal liability for surety, like he may not be directed to go to jail for failing to bring the accused before the court. A very interesting judgment was being passed in the case of Sanjay Chandra, this is Central Bureau of Investigation, by Honorable Supreme Court, which describes nicely about the liberty of the person. This case was being argued by Honorable Senior Advocate that time, Ram Jethmalani. This is the most widely judgment which is being used by the courts either in their judgments or by the advocates. This judgment talks about the liberty, the personal liberty of the person and why the person has to be released. I will like everyone to go through that judgment. The Sanjay Chandra, which is Central Bureau of Investigation. Now, bail in Sessions Court. Friends, with respect of bail in JMFC, I've already spoken about the procedure. The Sessions Court, the procedure is similar. Same procedure, we have to file the bail papers, ask for the safe from the police, and the judgment will be delivered by the court. What to be done if bail is rejected by judicial magistrate first class? Sometimes our bail may be rejected. Now, if a bail is rejected by the Honorable JMFC, we have two options. Either to wait till the happening of certain circumstance or change of circumstance, or file an appeal before Sessions Court and ask for the bail. Sometimes a circumstance may change and we may be granted bail. I'll give an example. Sometimes a person is being denied bail on the ground that there has been no recovery, and the bail is rejected. And in certain future, the recovery is being done. Then we can apply for the bail because no useful purpose will subside keeping me in judicial custody. Why bail has to be granted is because a person, if he's out of the jail, he can prepare for his defense. If a person has been kept inside the jail, then it will be difficult for him for preparing for his defense because he is being arrested only on the basis of accusations. The accusations may be false. Now, friends, further, if the bail is being dismissed by Honorable Sessions Court, then we can approach Honorable High Court. Similarly, we cannot directly move to the High Court under 226 if we are being arrested because we have not exhausted the remedies. Also, we need to understand the difference between a person who is being arrested and who is being detained. There are certain laws which makes the bail concept of bail next to impossible, because these are the detention laws. A person who is being detained may be refused bail time and again. In such circumstances, the only option could be to move for the writ of habeas corpus before Honorable High Court. I will not go in detail with respect of that. We'll restrict our webinar to the law of bail. Now, a person who is being in jail and he's being jailed for certain long period of time, if the police fails to file the charge sheet within a reasonable time as being laid down under CRPC, then the bail has to be granted as a matter of right, because the charge sheet has to be filed within a period of 90 days. It could be extended up to 180 days on the request of the police. But if the charge sheet is not being filed within the statutory period, a person needs to be granted bail, which is as per law. Now, a bail and parole is different. A bail is given till the final hearing, and parole is given to a convict or person who is being in jail to get out of the jail for a particular time by furnishing some surety or documents. Now, bail application, I forgot to mention the bail application. In bail application, you need to mention the correct detail address of the person who is being arrested. Now, you need to also mention the Aadhaar card, and the details had to be as per the identity card of the person. Because later on, certain judges are of the view that the verification of the address of the person who is directed to be released on bail has to be done. If your address in the title, cost title, and the document which you have produced doesn't match, then your bail may be subject to further scrutiny. Now, there is a very interesting judgment by Honorable Supreme Court that even a beggar could stand as a surety. The law is also well settled. It is not mandatory that person has to compulsory give surety if he wants to be released from the bail. In certain cases, court may take the personal bond and direct the person to be released. So giving the surety is totally up to the, or imposing the surety is totally up to the discretion of Honorable Court. Now, friends, what is the time limit for filing the bail? There is no time limit. You can file once the person is being arrested or any point of time when it comes to your knowledge that the person wants to get out of the jail. So this webinar is around for 30 to 35 minutes, out of which around, I think, 25 minutes have already been eloped. So I will request if any one of you all have the question or any query with respect of the bail or the law relating to the bail, could kindly be pleased to ask me. Okay. There is also a provision for cancellation of bail in 439. If a person who is being released on bail, if a person released on bail goes out of the jail or he moves out from the custody of the police, then if he goes and interferes with the investigation process, or he threatens the witnesses or tampers with the evidence, then it is rightful for the court to cancel his bail on the application by the state or the victim, and his bail could stand cancelled. Now, certain times, the conditions imposed conditions imposed could be not within the reach of a person. Sometimes a surety of 50,000 is being imposed. Then we have the remedy under section 439(2) of CRPC to apply for change in conditions of surety. And we can apply it either before Honorable Sessions Court or High Court, directing the JMFC or Sessions Court to modify the sentence. Now, with respect of habitual offenders, the bail may not be granted. But that doesn't mean that Honorable Bombay High Court in Saloni Naik versus State have held that a person who has committed a crime and is being granted bail, and if he's being arrested again, that does and being held and is being accused of committing similar crime, that doesn't mean that he has committed a crime or he will be able to commit a crime and he should be denied the bail. Also, with respect of habitual offenders, it will depend upon the facts and circumstances whether to grant the bail or no. So it's almost 6:30, and I think I have covered most of the topic. So I will take the leave from you all people. I will just keep the session open if there are any questions which you all want to address to me or which you want to ask me. I'm just waiting for that.
So just one question.
Yeah.
Sir, you have previously said that you will be talking about anticipatory bail.
Yes. No, anticipatory bail.
Yes.
Yeah. See, anticipatory bail, I'll just speak in 2 minutes.
Okay.
Okay. So, anticipatory bail is bail in anticipation. Meaning is very important. You anticipate arrest. Anticipatory bail could be sought from Sessions Court or you can directly approach the High Court. But it will be thoughtful to approach Sessions Court, because if you directly happen to approach the Honorable High Court, then the remedy for challenge doesn't remain if High Court dismisses your case. Anticipatory bail, you can directly move to the Sessions Court if you are under the impression or you get the knowledge that a false case has been filed against you and you may be arrested. The court may grant the anticipatory bail or the court may reject. It is not a matter of right. Sometimes the court may ask the person who is apprehending arrest to be present in the court at the time of delivering the judgment. And if that person is not present, the court may reject the bail. Here, I'm getting a question. Can we get the bail on immediately when person is arrested? Obviously, very important question and very good question. We can do the bail at the night time also, at 12 o'clock, 12 a.m. or 1 a.m. or 2 a.m. Going to the house of the judge, JMFC. The bail need not even be registered before the registry. You can directly move an application stating that I have been arrested, I have been falsely arrested, furnish the surety before the court and take your person home. This was questioned by Ashish Kumar Dixit. I think I hope I have cleared your query. Now, also, there's one more question. Sir, if the bail is denied, did the victim apply for the bail for after some time? Obviously, as I have stated, if your bail is being denied, we can ask for the bail if the circumstances change or you approach the Sessions Court challenging the order as being impotent order being invalid. Now, again, a question is being asked, what is anticipatory bail? Anticipatory bail is the bail which you apply in anticipation of arrest. Now, Aditya Dubey is asking me if trial has been conducted and accused has been filed guilty. You cannot ask for the bail, but you can give a personal bond under section 437A and ask for a time limit from the court of 6 months to stay outside if you are being held guilty. That in case you have been held guilty by the appellate court in case you're being held guilty by the appellate court, you will submit. So if a person has been out on bail and he's being held guilty, you can still apply for bail under section 437A. This is a question of Aditya. There is no time limit for applying bail, but there is a time limit wherein the charge sheet has to be filed. And in case the person doesn't file the charge sheet within the time limit of 90 days, the bail has to be granted as a matter of right. Okay, so e-certificate shall be issued to all those. I'll request again to send me your details on my mobile number, which I've given right after the end of this webinar. So by tomorrow or day after tomorrow, I could give you the e-certificates. So any more questions? Here I'm reading the questions. I think it's taken all the questions. So I'll thank all of you all for joining me on this beautiful Sunday. It's rainy here in Goa. The weather is also very awesome. I'm at home today. So it was nice and wonderful experience to learn with you all. This is my second webinar. You can follow me on the YouTube channel. I'll also upload this on the YouTube channel. So I hope we can organize this kind of more webinars and try to learn with each other. I think and I hope the webinar was useful. I'm getting some good comments from here. Thanks everyone. Okay, I'll take a leave, friends, because it's almost 6:30 and I'm being engaged in some other urgent work, which is going to start at around 7 o'clock. So I need to prepare for that. So I'll take the leave with the permission of all. May I leave with the permission of all? So I'm taking permission from all of you all, and thank you everyone for being present and supporting me, encouraging me. Thank you.
Thank you, sir. Thank you.
Yes, yes.
Thank you, sir.
Yes, yes. Most welcome, all of you all. I'm overwhelmed with the comments which I'm getting here.
Thank you, sir.
Yes, yes. Okay, I'll see you. I'll take the permission to take the leave from all of you all. Thank you.